Today I thought I'd briefly go over arbitration clauses and what they mean to you, and some areas where you actually can get out of arbitration, or at least negotiate your way out of arbitration if it's something that you probably wouldn't be interested in doing. So there's some arbitration agreements that if you want your favorite entertainment provider, or you want a certain cell phone, or you want to go to a certain place, that hey, you just can't have that cell phone, you can't have that entertainment provider, and you can't go to that place unless you sign the agreement, and that's going to bind you to arbitration. The good news about that kind of arbitration is it's usually going to be what's called a consumer arbitration, which means the defendant, if something should happen, will be required to pay for the arbitration. But in other cases, such as in a real estate purchase agreement, it's going to be completely voluntary for the parties to enter into arbitration. And let's talk about why you may or may not want to be in an arbitration. Well, the first thing about arbitration is it's extremely expensive. So in a real estate transaction where the parties agree to split the fees of arbitration, you're talking about tens of thousands of dollars just in arbitration fees, the fees you're going to pay an attorney to be the judge for your private court case. It's equivalent of going to private school, right? You pay taxes, you can go to court, and you pay a very small filing fee, and eventually one day your case is going to get called and you're going to get your day. If you sign up for arbitration, you're going to get to that result faster, and you're going to spend a lot of money to pay for all the infrastructure of that arbitration because it's not subsidized. You're paying it all. And so it's going to be very expensive. And so let's talk about why in a real estate contract you might want an arbitration agreement. Well, I have a case where a lady sold her house to someone, and the buyer has a very small, pretty much frivolous case against her, and it's for a little bit of money. Well, the buyer went ahead and sued her in court. We filed a motion to compel arbitration. A motion to compel arbitration is a bunch of complicated words that says, hey, you signed the agreement, now you can't be in court anymore. Let me tell you, motion to compel arbitrations get granted more than any other motion I'm aware of, because the court doesn't want you there. I mean, they'll tolerate you if you don't have another place to go, but deep down, they love sending arbitration to arbitration. And the Supreme Court has even weighed in on this and said, hey, if there's an arbitration clause and there's a motion to compel, the court freely should compel the parties to go to arbitration and stay out of the court system, because if we give any wiggle room to those types of contracts or those types of provisions, the next thing you know, we will have a whole court action and a long, lengthy trial about whether or not they need to even be in arbitration. So they're going to send you to arbitration if you sign this. So if you're a buyer of real estate and you're nervous about a latent defect, or you're worried about they didn't disclose something to you, or you're worried about something you should subsequently find, do you want to pay 50% of the arbitration to see if you can get that damage paid for? Or do you want to pay a small filing fee? I'll give you an idea. An arbitration easily in the first 3 months could run the parties both $9,000. And that's not even getting into a decision. That would just be the extensive discovery that's allowed in the real estate contract, and the judge holding conferences to talk about what you might do if you ever get to go to the actual arbitration. So would a buyer want that? I don't know, maybe. As a seller, maybe you do want it because it makes buyers think twice before they bring small claims that they probably could just handle on their own. Here's the weird thing. On all the brokers and agents that I help, I see these coming over the first offer from the buyer with this initial that they would like to go to arbitration by an e-sign. Does the buyer really want to go to arbitration? that means they're foreclosing pretty much any claims they're going to have against the seller that are below a large amount of money, just from a practical standpoint. Now, if you're a seller and it comes over and the buyer hasn't checked this, maybe you do want to check that because it's going to create a barrier to getting sued. Something to consider. In that case with the frivolous lawsuit I told you about, the plaintiff has never followed through after they were compelled to arbitration. It's been 2 years and they've never even written the first check. It's going to get dismissed soon. Here's another one in a solar financing agreement right here. Now this one's a little more lengthy, but it says that the borrower has the right to opt out of arbitration so long as they give written notice to the solar go figure, this solar financing company went bankrupt, but they had opportunity to opt out of arbitration if they gave written notice within 45 days. And so while arbitration clauses are everywhere, your employer may have had you sign one, you definitely signed one if you downloaded any software in our user agreement, it's important to know that arbitration strongly favors defendants over plaintiffs. And so if you're concerned of preserving any claims as a plaintiff, that might be something to think about the next time you make an offer on real estate, is to ask your agent, hey, what are we going to do about checking the arbitration box? So something to consider, because it's really complicated, expensive stuff. Most people don't know what it is. It's binding. So if your private judge makes a mistake, too bad, the court won't review it. So something to consider.